Fraudulent Misrepresentation by Larry Urueta. Fraudulent misrepresentation, at least in the context of contract law, fraud affects the authenticity of the innocent party's consent to the contract. If an innocent party consents to a contract with fraudulent terms, the contract can be avoided. The party can choose to either cancel the contract or seek damages if they incur any harms resulting from the fraud. There are three elements of fraud: a misrepresentation of a material fact, an intent to deceive, and the justifiable reliance of an innocent party on that misrepresentation. There are three types of misrepresentation. There is the misrepresentation of conduct, which is when a party takes a specific action to conceal a fact that is material to the contract. For example, when someone is selling a car and fails to inform the buyer of the car an important factor in the purchasing of that vehicle, such as an issue with that vehicle. There's also the misrepresentation of law, which states that a misunderstanding of the law does not entitle a party to be relieved of a contract. People are expected to know about their state and local laws before they enter into a contract. We also have the misrepresentation of silence, which is neither party has an obligation to come forward and disclose facts. A contract will not be set aside because certain information has not been volunteered.
Of local automotive repair shops are being shut down because of fraud allegations. KCRA 3's Tom Duhane live in Rancho Cordova with more. Tom.
That's right, and this is one of them, Walt. There are 5 of them that are being shut down. They were shut down early this morning. You can see the bay doors shut down, all under the title of, or the name of, Perfect Auto Service Centers. And as you can see, the entry room here completely empty, and a very large sign slapped on the front. It's a notice of suspension for the Department of Consumer Affairs, saying that they are closed until further notice. These are the perfectly good working auto parts that consumers were told had to be replaced. People paid.
So this is a good example of breach of contract, where a mechanic was essentially, advising its customers that it either needed to, or that they were making replacements to certain parts on their vehicle and actually not actually doing so, and continuing to charge the customers. One example of fraudulent misrepresentation.
800,000 cars across the country are part of an illegal business practice called title washing. That means a scammer will take a car that's deemed a total loss, also called a salvage title vehicle, fix it up, alter its documents, and then sell it to a buyer without disclosing that information.
This is another example of fraudulent misrepresentation, where certain car dealerships whose vehicles are essentially considered salvage vehicles, either due to some kind of flooding damage or some kind of weather damage that they don't disclose to the customers, and then they try and hide the fact that the vehicle is salvaged by moving it between states or changing the title in some way, which shows, that's another breach of a contract between the buyer and the seller. Another element of fraudulent misrepresentation is the intent to deceive, and it's defined by the term center, which is used to describe the knowledge by the misrepresenting party that the material facts have been falsely represented, or when a party knows that a fact was not as stated. It also applies if the facts are overstated or were exaggerated. That is an intent to deceive.
Lining the walls of the Springfield museums are the clean, evocative lines of Modigliani. Or is this the work of the troubled Italian master? Here hangs a piece by the iconic French artist Toulouse-Lautrec. Or is it here? In the new exhibition Intent to Deceive, the lines are more than blurred. They are inspired, mimicked, and forged. On these walls, you'll find some of the world's greatest artists, alongside the frauds who've successfully taken them on.
I thought this video might be a good example of intent to deceive, being that the name of the art exhibit was just that. But fakes and forgeries in the art world are essentially one of the bigger issues that museums face. And I thought it was interesting that in this exhibit, they show the original works of art alongside forgeries, and they intend to kind of inform the general public about what to look for in the original piece as well as in the forgeries that, you know, in the past at least have fooled experts, dealers, and other institutions. Another element of fraudulent misrepresentation is the reliance on that misrepresentation, where the deceived party must have a justifiable reason for relying on that information. Reliance is not justified if the innocent party knows that the facts are not true, and this also applies if the facts are overstated. If a reasonable person knows that, you know, that information is just not true, that would be considered not, the reliance on that information would be considered not justified.
An immediate sense of outrage at Lay and Skilling and Fastow when people realized how much they had profited and how completely artificial the appearance of this company had been.
That nobody could really understand, and in fact that many of Ken Lay's lieutenants questioned. They said this business can't be making this much money legitimately. Something weird is going on.
Mark-to-market accounting allowed Enron to book potential future profits on the very day a deal was signed. No matter how little cash actually came in the door, to the outside world, Enron's profits could be whatever Enron said they were.
Just another quick example, one of the more famous examples of business fraud. Back in 2001, Enron was accused of overstating its earnings. This ultimately led to the company's bankruptcy and also the loss of thousands of jobs for all of its employees. Obviously, Enron did not act alone, but I thought it was worth mentioning since we were talking about fraudulent misrepresentation.
New York today, Martha Stewart was indicted on criminal charges relating to an insider trading scandal that began more than a year ago. She faces 9 charges, including securities fraud, obstruction of justice, and conspiracy. The Securities and Exchange Commission also filed civil charges today, accusing her of, among other things, insider trading.
Just also wanted to add in an additional example, one of the more popular or famous examples, where back in 2004, Martha Stewart was found guilty of obstruction of justice and making false statements during an investigation into her sale of IamClone system shares. Here she had received an insider tip that a certain drug that was being produced by IamClone would be denied by the FDA, so she decided to go ahead and sell all of her shares for that company, which is illegal, and ultimately she lied about it into the investigation, which you know, led to the scandal and led to her doing actual jail time. So to conclude, fraudulent misrepresentation consists of the following 3 elements: misrepresentation of the material fact, the intent to deceive, and the justifiable reliance of the innocent party on that misrepresentation in regards to contract law. Thank you again for watching this video, and once again, my name's Larry. Have a good day.
When two or more entities are bound by a contract, and one of the parties bound to the contract violates the terms within the contract, a breach of contract has occurred. A breach of contract by one party may cause damages or losses to the other parties that are bound to the contract. An entity that suffers loss due to breach of contract can seek redress in court by suing the violator of the contract for monetary damages. Now here's where it gets serious. These are the 4 types of damages. 1. Compensatory damages. 2. Consequential damages. 3. Punitive damages. And 4. Nominal damages. Let's begin with compensatory damages. Compensatory damages are awarded to entities that suffered a direct loss due to a violation of the terms of the contract by another entity. In other words, compensatory damages are damages that compensate the non-breaching party for the wrongful acts of the breaching party. Compensatory damages are calculated by determining the difference between what was promised by the entity according to the terms of the contract and what was actually performed. For example, let's say I own a fertilizer manufacturing company called Grow Magic. Nitrogen is a vital component of fertilizer, and Grow Magic contracts a local chemical company called Nitro Valley to supply nitrogen gas for production purposes. The terms of the contract say that Nitro Valley will supply 5 tons of nitrogen gas each week at the rate of $5,000 per week. If Nitro Valley fails to supply nitrogen gas in a week because its workers went on strike over unpaid salaries, and Grow Magic has to source nitrogen gas from a much more expensive foreign supplier at the rate of $15,000 per week, Grow Magic has the right to seek compensatory damages from Nitro Valley for breach of contract. In this case, the compensatory damage would be $10,000 because this is the difference between what Nitro Valley promised would be performed and what was actually performed. Let's go on to consequential damages. Consequential damages are also known as special damages. These are damages that are known to the parties involved to be a consequence of breach of contract. With consequential damages, the breaching party is aware that its failure to meet the expected performance as stated in the contract will cause it to be liable for monetary damages. Let's go back to my example of Grow Magic and Nitro Valley. Let's assume that, like before, Grow Magic contracts Nitro Valley to supply nitrogen gas weekly. However, the contract states that Nitro Valley must supply nitrogen gas to Grow Magic by 12 p.m. every Friday, or else Grow Magic will experience severe disruptions to their production process that cause it to lose $2,000. If Nitro Valley fails to supply nitrogen gas by 12 p.m. on Friday, as stipulated by the contract, Nitro Valley is liable for damages, and Grow Magic has the right to seek consequential damages for violation of the contract and loss occurred as a result. We've talked about compensatory and consequential damages, but let's talk about what nominal damages are. Nominal damages are awarded when a breach of contract does not actually cause the non-breaching party any financial loss or damage. A business entity may be involved in a case of breach of contract where the entity does not actually suffer any loss as a result of breach of contract, but still seeks for damages to be awarded regardless in order to prove a point. A judge can choose to award nominal damages to a non-breaching party that suffered no loss in order to indicate wrongdoing by the breaching party. In my example with Grow Magic and Nitro Valley, Let's assume that they had a business agreement similar to the previous examples, where Nitro Valley supplies Grow Magic with nitrogen gas on a weekly basis. Like before, Nitro Valley fails to supply nitrogen gas to Grow Magic as a result of an internal worker strike at Nitro Valley. Grow Magic may be able to quickly adjust and source nitrogen gas from another company that offers products at similar pricing to Nitro Valley, thereby not having an impact on Grow Magic's production process of fertilizer or causing financial loss in the course of doing so. However, Grow Magic may still choose to seek nominal damages from Nitro Valley, regardless if Grow Magic did not suffer any actual financial loss or damage. It should be noted that nominal damages are typically relatively very small and can be as low as $1. Before we go, I want to touch on punitive damages. Punitive damages are generally penalties imposed by government or law enforcement officials. Since punitive damages are usually issued in criminal cases and contract law mainly has to do with civil cases, punitive damages are not normally involved in contract disputes. Punitive damages are not applicable to breach of contract cases unless a tort has been committed by any of the parties or a law has been broken. This is the end of my presentation on breach of contract and types of damages. I hope you enjoyed it and learned something new. Again, my name is Talabi, and thanks for watching.
So mistakes happen. Everyone makes them. There's all kinds of ways to make mistakes, and when it comes down to contracts, you really need to know what you're dealing with, because there's mistakes of quality, as in stating something might be a little bit better than what it is. There's also mistakes of fact, as in placing the decimal in the wrong position when you're trying to get paid for services rendered. And two types of mistakes occur when it comes down to contracts that make them voidable: unilateral and bilateral mistakes of fact. So the first type of mistake, unilateral mistake, is made only by one of the parties involved in a contract. It could be a mistake if I own a business and I want to print up some t-shirts for a high school. And the high school and I reach a contract on the t-shirts for $17,000 worth of materials. I send them over the contract. I forget to put in a zero, and it says $1,700 instead of $17,000. Now, the high school obviously knows that this is a mistake, and that would therefore make the contract voidable because it's a gross mathematical error and it's a matter of fact. So one of the parties made a mistake in drawing up the contract, my business, for the t-shirts. The price we had already discussed was $17,000, and $1,700 is what appeared on the invoice, so the contract would become voidable for $1,700, enforceable for $17,000. The second type of mistake is a bilateral mistake, and it is made by both parties in an agreement and usually makes the agreement voidable. A bilateral mistake can occur when a contract happens if I were to try to pay somebody to come and trim my palm trees. And as a part of the contract, it says to trim, remove, and dispose of all tree trimmings. Upon discussion with the company, we decide that they don't need to dispose of them because loose trash pickup is coming through my neighborhood, and no need of disposal required. So the contract itself is not changed. They complete the work. I cannot hold them liable if I turn around and miss loose trash pickup. Palm trees are still in my yard. Take my contract and say, well, it says here you were going to dispose of them. It is a bilateral mistake. They did not change the contract to state that the trash was going to be picked up by the city for loose trash pickup, and I did not have them change the contract to stipulate that either. So therefore, that becomes a bilateral mistake. Thank you for watching this presentation on mistakes, unilateral and bilateral definitions, and try not to make them. My name is John Ramsey, and this is for GBS205. I hope you have a wonderful rest of your day and stay safe.